welcome to The Law Matters. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. This long-running program continues to educate, inform, and help you with law matters because the law matters. A better understanding of the law puts you in a better position to decide how to protect yourself, your family, and your business at times. In each segment, we provide information and resources that may help you decide whether or not you need to contact a lawyer. In some cases, you may not. Our goal, of course, is to help you to achieve the best possible results while saving time and money. And in the interim, if you do decide to retain a lawyer, you'll be better prepared, and so will the counsel you select. The Bazaar & Associates law firm in East Providence continues to help us as we tackle various topics. We appreciate Attorney David Bazaar for joining us, lending his experience, his legal information, and his insights. Today, court jurisdictions might sound a little bit drab, but it's very interesting to understand the difference between the state and federal court systems. There are differences in courts, in the structure, the judicial selection, the cases that are heard, and interestingly, we have two in this area that have become memorable, some would say perhaps even notorious, namely Plunderdome and former Mayor Buddy Cianci, and Governor and his son Ed DiPrete, who also had a very noteworthy case. Both involved some bribery and extortion. They're different. We'll find out why. For you, you might want to know what the differences are between state and federal. There are times that it might matter to you, and you might have a choice, and how it's handled, what it might cost, the time that it might take, very different circumstances. So let's turn to our legal eagle, David, and say, okay, David, what is the 411? What are the differences between the state and federal court systems?
So first of all, it's jurisdictional.
Jurisdictions.
And
yes.
Then you have to look at what type of case we're talking about, civil versus criminal, in each jurisdiction. So the state court has jurisdiction over state issues, and that can be criminal statute and therefore criminal cases or civil cases. The federal court has jurisdiction over federal issues and federal law, and both criminal and civil on that matter. And then for civil cases where there could be jurisdiction in either court, it depends on certain factors such as diversity of citizenship, even though it might be a Rhode Island personal injury case, if the parties are from different states and the controversy or amount in controversy exceeds a certain threshold, you might be able to remove it from state court to federal court. That's the nutshell.
Is it safe to say that the state courts are broader in their scope and the federal courts are somewhat narrower, as you're talking about, I don't know, bankruptcy and what are they, copyright, and maritime law or whatever, are they more narrowly focused in general?
So what you just mentioned were three types of jurisdiction in federal court because it's based on federal law. Federal law. So whether it's more narrow or broader, I would think that the better description is what's involved in the case. So if it is a case about an accident on the high seas and it's maritime law or admiralty law, then federal court will have jurisdiction because that's where the statutes that are in question are being brought to suit. If it's broader in the sense that there are more types of cases that you might bring in state court versus federal court, that's not quite the way to look at it. It's really more based on what type of case is involved and therefore where the jurisdiction might lie.
Okay, and while we're talking about jurisdiction, what's the difference between jurisdiction and venue?
Okay, so jurisdiction and venue really look at similar things but different. So jurisdiction is, does the court have, first of all, subject matter jurisdiction, which means the right to hear the case at all. And so if we take a state court case, for example, of evictions, landlord-tenant cases. In Rhode Island, those cases are heard in district court because district court has the jurisdiction to hear those cases in the first instance. If you appeal those cases, then there's an appeal process that might take you for a new trial in Superior Court. But the jurisdiction, subject matter-wise, would be in the district court. Now, venue would be, where is the case supposed to be heard within that court system? So, for example, if the homeowner and the home and the resident of the house that's being in question is in Providence, then venue would be in the Providence District Court, as opposed to if it's in Westerly, it would be in Washington County District Court.
So for those of us who follow some of those network law shows, we often hear that someone may want to have the venue moved because they don't feel that they would have a fair trial because too many in that location were already too informed, too close to it. And is that a viable thing that you are familiar with?
So yes, and it's a good question. And so, for example, we'll stay with the state. Rhode Island's too small to really do this with, so let's have a case in California. So let's just say that there's some very well-known, notorious case, or let's make it a criminal case, that happened in Los Angeles. And the court system in Los Angeles, let's just say, I'm not sure that familiar with it, so we're going to make this up a little bit, is Superior Court for the County of Los Angeles, or whatever that might be. And the jury pool that would be pulled from Los Angeles, the concern might be that everybody knows about this case. There's been a lot of publicity about this case right within that little county or big county. And so therefore, in order to have a more fair jury pool, we want to move it from Los Angeles to San Francisco. Jurisdiction still within the Superior Court, as I laid it out, but the venue is being switched for purposes of having a broader, more fair jury pool.
So you mentioned something earlier about, of course, you were making up the case, but it does it not point to the issue about various states? They have the ability to determine what their court structure and setup is versus which is something you might not be familiar with in speaking in some Rhode Island, Mass, Connecticut, or whatever, versus the West Coast. So someone should be aware that there are different structures in various states.
Right. So we'll take Rhode Island as an example. Depending on the type of case, there's District Court, Superior Court, and the Supreme Court. District Court, as I said, has jurisdiction over landlord-tenant, for example. They have initial jurisdiction over misdemeanors. Superior Court has jurisdiction over felonies, and if you waive your right to a trial in the first instance in District Court, that would go straight to Superior Court. And the general trials, civil matters under a certain amount, $10,000, might be heard in District Court in the first instance. Over that, Superior Court for general trials, most cases where there's equity decisions or equitable issues that need to be decided that aren't for money, but for example, you need an injunction against an employee from leaving or for going to work for a competitor. Jurisdictional equity is generally in the Superior Court. It's a court of law and a court of equity, so to speak. Law meaning you're suing for money, equity meaning you're asking for somebody to be ordered not to do something. There has been, by statute, equity given to certain other courts. For example, family court has the ability to issue restraining orders in domestic violence cases between people who are related, and District Court has also been given certain jurisdiction for restraining orders in other areas where you're not related by blood or marriage, so to speak.
And while I don't want to get into the weeds about this portion of it, as you described the various courts at the state level, could you briefly give an overview about what happens at the appeals level? Because someone at district court level may not exactly like, for whatever reason, that outcome, and how does that change?
Depending on the type of case, many cases from district court can be appealed for a new trial, or what they call de novo, to Superior Court. So if you chose to have your misdemeanor case tried at the district court level in front of a judge, because district court does not have juries, so you waive your right to a jury in the first instance to have the district court hear your case. If you don't like what the judge decided, you then have the right to appeal that to Superior Court for a de novo trial, meaning a brand new trial, where you might have the right to a jury at that point because you gave it up only in the district court. So now you're in Superior Court, you have a new trial. There are other types of cases that might be heard in Superior Court that are now, you didn't like that decision either. You might either have a right to appeal to the Supreme Court, or you might have the right to appeal by what's called a writ of certiorari, which is where there's not a direct right of appeal, but a discretionary appeal where you file to the Supreme Court and they'll look at it and decide whether they'll hear that case or not.
Thank you for saying that, because I was going to ask you about that too. So in a situation where you have a state and federal courts jurisdictions, there are occasions when it might apply to federal or state, and when both options are available, the plaintiff can choose. Under what circumstances might that occur, David, and what kinds of things would impact on someone's judgment if they had that judgment?
So I was talking a little bit about diversity cases, for example, and the defendant might get to choose as well in that type of case, and here's what would happen. Let's take the plaintiff. He's got a personal injury case against a manufacturer, let's just say, that doesn't do business in Rhode Island. And he bought a product in another state. The defendants are all corporations that aren't incorporated in Rhode Island, perhaps. And he sues in Rhode Island because he wants to hear the case heard in the Rhode Island Superior Court for whatever reason. And oftentimes it's because that's where the lawyer who's filing the case might be most comfortable. So they file in Rhode Island Superior Court. The case is worth more than $100,000 or whatever the diversity amount is. And the defendants come in, or one of the defendants, if it's just one, and answers with a motion to remove the case to federal court based on diversity and the amount in controversy. And now the case is removed to federal court because they have jurisdiction and you have a right to have your diversity case heard in federal court. The plaintiff could have chosen to bring it in federal court in the first instance.
So we always hear that everyone has a right to an expedient trial. Address, if you will, the differences between costs and length of the time that it takes to go through a case. What impacts on each of those cases that someone might need to know about if they're needing to make that decision? Cost. Does it cost less to be in state court versus federal court, and why?
Well, it may or may not. It depends on what the attorney's fees are. So, for example, if you're the plaintiff in a case where there's a personal injury, it's a contingency fee. That's not going to affect your fees.
Okay.
The defendant who's paying somebody perhaps by the hour, maybe the attorney in federal court might want to charge more than the attorney in state court. I can't really address that. That's on a case-by-case basis.
Okay.
But in general, I think what you need to know is that there are more cases heard in general in Superior Court in Rhode Island than there would be in the federal court. Therefore, the federal court judges tend to move their cases along much more quickly because they can.
So, in doing a little research here, the issue about discovery, which happens in all cases, there was a point that suggested that the discovery process is different in state versus federal. And it's often a high cost to go through that discovery process. It might be, allegedly, that federal court might take more time, be more involved if it's gone to a federal jurisdiction. True?
Yeah,
Care to comment?
I think generally speaking, the federal court moves the cases along quicker than state court. You do think so? I do. And whether they're more involved or not, it's really a matter of motion practice. If you don't think you're getting the documents or the information or the discovery that you're entitled to, you file a motion, and in federal court that usually go to a magistrate judge first, and then if you don't like that decision, you might be able to have the actual district court judge weigh in on it. In Rhode Island, and the motion practice is done in front of a motion judge. So Rhode Island doesn't generally, there are some exceptions, but generally assign a case to one judge. It's generally in the pool of all the judges, and then The motions are heard by whoever's the judge on the motion calendar. If there are some other aspects that need to be heard by another judge, they would be. And then it's assigned at some point to trial, where it'll get assigned at the time of trial to one judge to hear the trial.
So we often say there are times that our viewers might want to go it alone, pro se. With something like this that you're describing, motions and motions that might be challenged or referred out, would this be a kind of situation that if there's many motions that need to be taking place and there's a long period of discovery, is this something that suggests someone should go it alone? Or could go it alone safely?
You can, but I would suggest that when you get to the point where you're involved in litigation, where there are motions and there are issues and court rules that you have to follow, it would not be my recommendation that that's a do-it-yourself kind of job.
Okay. And in talking about the speed of state versus federal, I had heard comment on state courts sometimes can fast-track cases, and they refer to them as a rocket docket. Is that true?
There are certain jurisdictions within or cases within, for example, Superior Court jurisdiction, where they can be moved along quicker. For instance, there's a business calendar where there is, in that type of case, one judge assigned to a case who will hear the motions, who will be intimately familiar with the case, and will move those along quicker, because oftentimes the business issue that's being challenged needs quick attention. So that is true.
So when it comes to doing state case versus a federal jurisdiction case, how are the steps? Are the steps in the trial the same, or go through those processes?
Yeah, generally a trial is the same in either. There are certain court rules that are different. There are rules of evidence that will be different, but the process is the same, which is, generally speaking, voir dire, handled differently in each court. The voir dire of a jury panel in federal court is, again, generally handled not by the trial judge, but by the magistrate judge, who brings in a whole bunch of different cases at one time to impanel those juries, whereas in Superior Court, your jury panel is brought in for your trial, so the voir dire is handled by the trial judge. After voir dire, you then go to opening statements. We're talking civil cases, in both courts, and then the case generally proceeds in the procedural sense in the same way, where the plaintiff presents his or her case, the defense will then present his or her case, and then closing arguments, jury instructions, and jury decision.
So similar, very similar process. And
different rules, similar process.
Okay. When it comes time to comparing state and federal courts, what other things might cross your mind that someone would want to think about if they had the decision to make at all? What other things might you want to consider if you were the defendant, for example?
Well, I think, again, I think in general the cases proceed quicker in federal court. So if you're looking to push this along, and there are certain rules of discovery that might be a little bit more beneficial in one court or the other, that's something you might take into consideration. Again, as I said at the beginning, I find that it's the attorneys and where they're more comfortable. Is the attorney more comfortable in federal court or more comfortable in state court?
If you were thinking about interviewing and selecting a lawyer, how might you find out about who would be better suited at which court?
Well, I think it's just a matter of talking to the attorney and asking them, what's your experience? Where have you tried cases? Have you tried cases in federal court? Have you tried cases in state court? Why do you think my case should be in federal court versus state court, or vice versa? And then weigh in, balance the attorney who might be more comfortable in federal court and why they're giving you advice to go there versus state court.
Good advice for someone who is screening or considering who they might need to retain for a case. So we've had two very interesting cases that are in the books now, as they say. In contrast, the difference between our Mayor Cianci and Plunderdome and Governor and Ed DiPrete. Both had some conspiracy and extortion and bribery. talk about jurisdictions and how the cases are handled, please.
So, as you know, we talk about these things from strictly the legal perspective,
Yes.
not the political
Yes.
perspective. But it is very interesting at how those cases were looked at back then versus how very high-profile governmental officials being investigated today are looked at.
Why do you say that?
I say that for this reason. The jurisdictional issue is really based on primarily who's investigating the case. So the difference between Governor DiPrete and Mayor Cianci's cases were the FBI investigated Mayor Cianci, the state police investigated Governor DiPrete.
Why did that happen, David?
Because those were the two agencies that took up the cases.
They just happened to each have some information, and one said, FBI said, I'll take this one, and
Right.
this is what
Yeah, and they do talk about that quite often. And both of those cases could have had state laws violated or federal laws violated. The FBI investigates violations of federal law. And so in Buddy Cianci's case, they looked at those federal laws, they brought an indictment against him, and they tried it in federal court. In Governor DiPrete's case, the Attorney General looked at violations of state law and investigated them and brought it in state court. Now, compare that to today, and as you do that, just look at how the cases were looked at back then. Nobody was saying that the investigation of either of those two politicians was based on political motivations or anything else other than violations of the law. Whereas today, people complain that the district attorney in New York who's investigating violations of state law is politically motivated, or the attorney general in Georgia who's investigating violations of Georgia law is politically motivated, or the FBI/Department of Justice, which is investigating violations of federal law, is politically motivated. What they looked at back then was some people really like Mayor Cianci, really like Governor DiPrete, but we don't think that the Attorney General or the U.S. Attorney or the FBI or the state police were politically motivated.
Good point. Would either of those, Governor DiPrete or Mayor Cianci, have the ability to say, I want this to be tried in the state? In Cianci's case, for example, right. You said the FBI was at it.
Yep.
That was definitely federal. He
right.
didn't have an option.
And neither would have Governor DiPrete to say, I'd rather be in federal court. Unlike civil cases where you may, depending on the type of case, be able to choose what court you want to go to, criminal cases are based on the criminal statute that's being violated, that you're alleged to have violated. And so if it's federal and the FBI is investigating that, it's federal. You can't say, no, this could have been a state charge too. I want to go with the state charge. You don't get to pick that.
So RICO, define what it is, and something that I learned, it could be either state or federal, and again, how does that usually become determined? So what does RICO stand for?
So RICO was originally the Racketeer Influence Corruption Organization Act of some type, which was brought primarily it was a federal law, which was designed to try to combat organized crime, mafia. And it was designed to say that if you have somebody killed, for example, but you didn't do it, can that charge then come back against you? Are you running an organization, a criminal enterprise, so to speak? And if you do, that's a violation of that RICO Act. So you can be charged criminally for all of the offenses that everyone in your organization committed. That there are some state statutes that are similar, and so again, the state cannot bring a federal charge, but if there's a statute that's similar, they can bring it based on that. And so if the FBI, for example, is investigating a crime, and it's now not used just in organized crime types of cases, but any kind of case where there's an allegation that there's a criminal enterprise, it enhances and broadens the types of criminal activity that they can investigate.
As I was reading, at issue was that entity was city government at Providence City Hall.
Right.
And so that changed the nature, I guess, of who wanted dibs on that.
Right. And so there could have been state crimes being committed. In fact, there probably were. Mm-hmm. But the agreement was that we're going to let the federal government, who had been investigating it first, perhaps, continue with that rather than cross, over each other's jurisdiction and step on each other's toes.
And at the appeal level, I think I recall Mayor Cianci had a couple of rounds of appeals. And how did that play out? It's at the federal level now, not the state level, as you were describing earlier. So where did that go from its initial case,
right,
and he asked for or had appeal? I think the issue about the writ of certiorari came up as well.
So it starts with this. First appeal, first case is tried at the trial level in the U.S. District Court for the District of Rhode Island. The appeal from the U.S. District Court for the District of Rhode Island is to the First Circuit Court of Appeals, which I think sits in Boston primarily. And the First Circuit Court of Appeals hears appeals from the districts around New England, mostly. And then that case is decided there. And if there's an appeal from there, that's when it's by writ of certiorari to the U.S. Supreme Court, which can decide whether or not it's going to hear that case at all.
I don't believe they did.
They did not.
They decided against doing that, and he served some time. So in the Plunderdome case, which was federal, FBI was investigating. There were others, underlings, who were involved too. If the top gun, namely Mayor Cianci, was being investigated and prosecuted, would that necessarily mean that the underlings too would all go as part of a federal case, rather than the underlings maybe not could have had? They obviously were investigated by state police at the time too, but feds took the lead on it. Would that have ever been split, or could it have been split? Could Mr. Carenti say, I think I want to go to the state police instead?
He can't decide.
He can't.
The state can. If the federal government decided not to prosecute anybody else, and the state police or the attorney general thought that, well, there were crimes committed that were Rhode Island violations of Rhode Island statutes, and the federal government's not pursuing those, we can. And that's not a whole lot different than the DA in Manhattan saying that there were laws violated here that could have violated federal laws, but the federal government decided not to prosecute them, so I am going to investigate that and determine whether or not an indictment should be sought from the grand jury here. So if Rhode Island U.S. attorney decided that we're going to prosecute the top dog and we're not going after anybody else, and we didn't enter into any agreements with anybody else for testimony, that would have left the state free to investigate if they wanted to.
So unlike what's going on now, there is a federal issue regarding our former president, as well as the state having dibs on what they think is an issue. Can it happen that the two are in tandem, that there's a state jurisdiction that's pursuing some cases and federal? Could it have been going on with the Cianci issue as well?
Yeah, but generally speaking, it's going to be usually one or the other. If it's for the same action or same activity. It happens, but yet generally speaking, the two agencies will work together and say, no, you take the lead, this is your case.
That settles out.
Usually.
Good to know. We hope that you've found this information helpful, and we hope that the insights that David offers will be helpful to you should you need that. We appreciate your staying tuned to The Law Matters. As we say, it matters to you. Thank you for tuning in.